last lecture we were doing section 19. So in the last lecture we were doing section 19 and we completed the substantive part of it. We completed the entire aspect of section 19. So in the last lecture we primarily dealt with the situation of check. So first we understood what will if the payment is made by check, what will be the date of payment as per section 19. So I told you that the date mentioned on check will be the date of payment. The first thing that we understood was the date mentioned on check will be the date of payment. Fair enough. Then the second question that arose was, what if the last day of the prescribed period, the date mentioned in the check is the last day of the prescribed period, and on that day, bank is closed. So date mentioned is last day of prescribed period, last day of PP, and on that day, bank is closed. Bank closed on that day. Then what will happen? So I told you that, see, in that case also the period of limitation will refresh from the date of check. So refreshment will happen, or the period of limitation will again start, or it will refresh again from the date of check. So the period of limitation will refresh from the date of check. This is the first aspect that we dealt with. And then we went on to understand, what if the check dishonors? What if the check has been issued and it dishonors? So if the check dishonors, if the check has been issued and it ultimately dishonors, then what will happen? Then the period of limitation will, if the check dishonors, then whether the person will get a benefit of section 19. So I told you there are two views on this. One is a Patna High Court view, one is a Punjab and Haryana High Court view, and the other is a Delhi High Court view. So I told you first, explained you what Patna High Court and what Punjab and Haryana High Court say. Punjab and Haryana and Patna High Court say that if the check is dishonored, then the payment will not be said to be a payment under section 19, and the benefit of section 19 or the acknowledgement will not be applicable, and the period of limitation will not be refreshed. Simple as that. On the other hand, Delhi High Court says that if we apply this interpretation, it will be a problematic situation. What will happen? Person can actually undo the benefit which the plaintiff has accrued by just doing a tortious act or by just dishonoring the check. So that is the reason in such cases we will deem, even though the check has been dishonored, we will deem that the payment has been made and we will refresh the period of limitation. हम मान लेंगे कि यार payment हो गई और period of limitation आगे बढ़ेगा. So we'll deem the payment for the purpose of section 19 and we'll provide the benefit of section 19 to the plaintiff. Now, these were the two things that we went on to understand in yesterday's lecture. We dealt with the three cases also. One of Patna High Court, one of Punjab and Haryana High Court, and the other of Delhi High Court. And I told you how Delhi High Court view is more plausible. The reason being that it is based on the concept of equity, justice, and good conscience, and it understands the purpose of section 19. It is a view that furthers the purpose of section 19 rather than defeating it. That is the reason we will consider section 9, the view of Delhi High Court. Okay. So with this, we ended our lecture, and we also did explanation A and explanation B. Explanation A spoke about usufructuary mortgages. Explanation A basically spoke about usufructuary mortgages, wherein the person is getting rent and profits from a mortgage. When a mortgagee is getting rent and profits, then that will be a valid acknowledgement. Explanation B spoke about debt. Okay. And it said that debt does not include, it's an exclusive definition. It says that debt does not include what? Any amount that is payable, money payable from a decree or an order. So decree or order se jo bhi amount payable hai, usse debt does not include that. So these are the various aspects that we went on to deal with, and we'll start with section 20 now. We'll understand section 20 and then we'll proceed further. एक बार section 20 से start करते हैं. Now see, what does section 20 do? Section 20, can you explain explanation C तो है ही नहीं. There's no explanation C, I suppose. अच्छा 18, section 18. Yeah, that I'll explain in the end. Explanation C, I'll explain in the end. Let's move on to section 20. Now let's start with section 20. Now section 20 says Section 20 is basically a supplementary provision, and it supplements or it explains. You can say it supplement or explains whatever has been provided in section 18 and 19. There is one term that has been provided in section 18 and 19. Your section 20 tends to supplement or explain that word. So what is that word? That is an important aspect. So come to section 20. एक बार आ जाओ section 20 पे. Come to section 20. Are you guys in section 20?
Yes, sir.
Yes, sir.
Okay. So section 20 says that the expression agent duly authorized in behalf. So the word agent duly authorized in behalf. So basically section 20 tends to explain this word, agent duly authorized in behalf. It seeks to explain this word. What does agent duly authorized in behalf means? What it means? So section 20 says that, see, this word you must have seen in section 18. You must have seen in 19. You must have seen that an acknowledgement can be made by an agent duly authorized. You must have seen that a part payment can be made by an agent duly authorized in behalf. Now, what does this agent duly authorized in behalf mean? Who is this agent duly authorized in behalf? Section 20 explains the same. So that is the reason I am saying that section 20 supplements or explains the words used in section 18 and 19. So it says that 3 people will be considered to be agent duly authorized. You can remember them as LCM. LCM. So one person is lawful guardian. Lawful guardian is an agent duly authorized. Now a person who does not have any lawful guardian, who takes care of him? Committee takes care of him. Second agent will be committee. Fair enough. And then comes manager. Manager, if it is a company, then manager is an agent duly authorized. Company or an organization, then the manager is the agent duly authorized. Then agent duly authorized are these 3 people. One is a lawful guardian, committee, or a manager. So an acknowledgement will be valid if it is made by these people also. Not only the person who is liable, but also agent duly authorized, meaning lawful guardian, committee, or manager. Now the question is that can they further delegate their power? Can they further appoint the agents? The answer to this is yes, they can further delegate their power. They can further appoint agents. And those agents also will fall under the definition of agent duly authorized. They can further appoint agents, and those agents will be considered as agent duly authorized. This is what has been provided in section 20 subsection 1. Okay. So section 20 subsection 1 pe come to section 20 subsection 1. Are you guys section 20 subsection 1? The expression agent duly authorized in section 18 and 19 shall, in the case of person from disability, include lawful guardian, committee, or manager, or any agent duly authorized by such, or any agent which is duly authorized by these people. So even if an agent is authorized by a guardian, that agent will also fall under this. If the agent is authorized by a manager, that agent will also fall under the definition. So not only these guys, but also their agents will fall under the definition of 20 clause 1. So this is what the 20 subsection 1 is trying to say. What is committee? Late aayo kya Kaushiki? Committee is basically what happens once the first authority is to maintain any person is of the lawful guardian. If there is no lawful guardian, then ultimately the committee, the responsibilities of the committee. So committee can be a waqf. Waqf is a committee in Muslim law. In Hindu, the committee can be any committee authorized by the court. Okay. So these are the 3 people who are agent duly authorized. Fine. Now this is one aspect. So they have clearly said that agent duly authorized are LCM. So they have restricted agents. They are saying that This LCM is agent duly authorized. Lawful guardian, committee, manager, these are the agent duly authorized. Fair enough. And because the person who is liable is suffering from disability, so these are the people who are managing, who are responsible for all the liability. So lawful guardian, committee, manager, and their agents. Fair enough. Now come to subsection 2. Subsection 2 brings something interesting for us. Subsection 2 says, starts with a saving clause. Subsection 2 starts with a saving clause. Fine. So your subsection 2 starts with nothing. Fine. It starts with saving clause. It starts with nothing. Fine. So basically, what does subsection 2 is trying to do? It is saving certain ingredients provided in subsection 2 from the rigor of subsection 1. कहने का मतलब है, subsection 2 is saying that there are subsection 1 talks about agent duly authorized. Subsection 2 is saying that these people are not agent duly authorized. Subsection 2 is basically saying that these people are not duly authorized, and it is trying to save from subsection 1. वो बोल रहा है कि यार subsection 1 में जो लिखा है वो तो है ही है, but ये लोग नहीं है, ये लोग नहीं है. These guys are not agents duly authorized. So what are those? What are those people? देखिए, nothing in the said section renders one of the several joint contractor. So first is one of several joint contractor. So पहला है joint contractor. Joint contractor is not an agent duly authorized. ठीक है? Or a partner. A co-partner is not an agent duly authorized. Or an executor. An executor is not an agent duly authorized. Or a mortgagee is not an agent duly authorized. Chargeable by reason only of a written acknowledgement signed or made or payment made by agent of any other or others of them. So basically they are saying that if one of the joint contractor, he acknowledges a debt, that will not be an acknowledgement for the other person. If one partner, he acknowledges a debt, that will not be an acknowledgement for the other person. Same is the case with executor. If one executor, he acknowledges the debt, that will not be an acknowledgement for the other person. If a mortgagee acknowledges a debt, that will not be an acknowledgement for the other mortgagee. So basically, even though they have some amount of agency, but they have, for the purpose of acknowledgement, they have maintained an individual relationship. They have said that an acknowledgement of a person, since he is admitting liability, that will be that he is admitting his own liability. So he should only be liable for that. So if any other person is admitting liability, it should not put in or impose a liability on the other person. दूसरा कोई अगर liability admit कर रहा है, तो वो liability दूसरे किसी बंदे को affect नहीं करनी चाहिए. It should not affect. That is what it is trying to say. So the subsection 2 basically saves these relationships, and they are clear about it, that just because a joint contractor has admitted a liability, that will not amount to admission in the cases of his partner or co-contractor. So it won't amount to admission in co-contractor. Just because a partner has admitted his own liability, then it won't amount to an admission of his co-partner. Just because an executor has admitted his liability, that will not amount to the admission of the liability of co-partner. Just because a mortgagee has admitted his own liability, that will not amount to admission of co-mortgagee. Now, what if it is a partner? A partner admits his liability. What if a partner admits his liability? What if the partner admits a firm's liability, not his own liability? What if partner admits a firm's liability? Will that be a valid acknowledgement? What if the partner admits a firm's liability? will that be a valid acknowledgement? See, when a partner is
Yes.
admitting firm's liability, that is a valid acknowledgement. Because here he is acting in a collective position. In these cases, they are acting in an individual position. So that is the reason you are not you're not holding them liable for the acknowledgement of the other. इन सब चीजों में हर कोई अपनी इंडिविजुअल पोजीशन में खेल रहा है, तो इसके लिए आप एक का एक्नॉलेजमेंट दूसरे पे डाल नहीं रहे। पर अगर उनकी पोजीशन ऐसी हो कि वो कलेक्टिवली सबको रिप्रेजेंट करे और वो एक्नॉलेज करे, then in that case it will be a valid acknowledgement. In that case, subsection 2 will not apply, because subsection 2 says that merely because he is a partner and he is acknowledging, just because he is a partner and he is acknowledging, that will not hold the other partner liable. But here he is not merely a partner. He is a partner who is responsible for the debts of company. So जो mere word है ना, उसका extension हो गया है. Fine. तो एक्नॉल मतलब सेक्शन सबसेक्शन 2 यही कहने की कोशिश कर रहा है कि जस्ट बिकॉज अ पर्सन इज अ जॉइंट कॉन्ट्रैक्टर, जस्ट बिकॉज अ पर्सन इज पार्टनर, जस्ट बिकॉज अ executor is a partner, executor is there, just because a mortgagee is there, their acknowledgement will not amount to acknowledgement of other people unless they are in some special position. Unless they are in some special position. स्पेशल पोजीशन, ठीक है। अब आ जाओ एक्सप्लेनेशन ए पे। नाउ कम टू सबसेक्शन 3। यहां तक क्लियर हो? यस तनिष्का।
सर ये वाला पार्ट एक्सप्लेन कर दीजिए।
ठीक, कहने का मतलब ये है कि ये सारे जो रिलेशनशिप्स हैं, जस्ट बिकॉज इन रिलेशनशिप से होने से, जस्ट बिकॉज एक पार्टनरशिप होने से ये नहीं हो जाता कि एक पार्टनर एक लाइबिलिटी एडमिट करे एंड द अदर पार्टनर इज ऑल्सो लाइबल. Just because of this relationship, mere relationship does not give a collective effect to the admission, to the acknowledgement. Rather, what is required is that the partner is in a position of representation. If he is in a position of representation, meaning that he is representing the other partner, in that case, his acknowledgement will also amount to the acknowledgement of the other partner. So, meaning that ये सारे relationship में होता है, ये सारे relationship में भी होगा कि if any of the person is in representative capacity, is in a representative relationship and he is representing the other person, in that case his acknowledgement will amount to the acknowledgement of the other person. Clear?
तो क्या ये ज्वाइंटली वर्क कर रहे हैं, इस वजह से एक रिप्रेजेंट कर रहा है तो बाकी पार्टनर्स भी साथ में उसको होल्ड करेंगे
इसमें
सर पार्टनर में?
हाँ,
सर जैसे फर्म वाला बताया था वो
तो रिप्रेजेंटेटिव कैपेसिटी है ना, वो फर्म वाला ही मैं बोल रहा हूँ ना, ये फर्म वाला एग्जांपल बोल रहा हूँ ना। क्या होता है कि देखो, व्हेन यू आर इन अ फर्म यू डोंट गिव ऑल रिस्पॉन्सिबिलिटीज टू वन पार्टनर और ऑल पार्टनर्स. सपोज देयर आर 3 पार्टनर्स, you tell one partner to deal with debts, you tell one partner to deal with property, you tell one partner to deal with goods. Now if the partner who is dealing with property, he admits a liability, will that be a valid admission? No, because that is not his responsibility. वो responsibility थोड़ी है उसकी, he is not authorized to do so. So just because he is admitting, you cannot hold other person liable. But if he is in such a position wherein he has been given a responsibility of admission, other partners have authorized him, if you want to admit, you can admit. So in that case, it will be a valid acknowledgement for all of them. Fine? Clear?
Okay, sir. Fine.
Yes, Lokesh.
Sir, in this example now, you said it's a partnership form.
Hmm.
So it's an individual entity. Now
Yeah.
you're saying that one partner is responsible to take care of the debts.
Yeah.
In that case, why are we not considering his acknowledgement, sir?
Yeah, if
He is talking on behalf of the firm.
No, if he is responsible for debt, then it is a valid acknowledgement.
Sir, even if he is not responsible, like if he is talking about the debts of the firm,
No, then we cannot, because he's not authorized now. Unless he's not authorized, so he'll be individually held liable. We
Sir,
cannot
but
hold the
if he is
entire
a
firm liable. You haven't authorized him, no? You haven't authorized him. There are some responsibilities. You do not give all the responsibilities to all partners. If he is authorized, if you have authorized him to admit a particular debt, then
so for clarification, are these partners standing with the same capacity, or
as
as in like do they have the same powers?
no partners can have same powers. If at all you are saying that they all are in one third,
Partnership.
one third. Fine. If you are saying that they are all are in one third, one third, you cannot. There there cannot be an implication that a partner can admit a liability. It cannot be an implication. It has to be either written in the partnership agreement or the partners have to agree. If they haven't agreed on that, one of the partners can admit liability and he is admitting liability, in that case, that will not be a valid acknowledgement.
Okay, sir.
He himself will be held responsible for the amount debt, but not the other.
Okay.
Okay. Chalo.
Sir, one question.
Yeah. Yeah.
Sir,
Rohit.
if hello, sir. Am I
Yeah,
audible?
yeah, Rohit.
Sir, if there are two contractors who came together for a project, and any one of them, they both are in equal capacity, and any one of them just acknowledges the debt, so won't it be for both for the whole?
No, depends what is the contract. Just mere relationship of them coming together will not hold the other person liable unless they have agreed that they will be held liable for the debts of the other.
Okay, sir. For a single project, the project is one
Or
only.
even if it is for the single project, mere liability, if the agreement is such, if the agreement of the contractor is such that they will be held liable for all the debts together, then an acknowledgement of one will amount to another.
Okay, sir. Okay, sir.
So subsection 2, if you want to understand it more clearly, subsection 2 is trying to say that these relationship, just because these relationship exist, that does not mean if a one person is acknowledging, the other person will be held liable for the acknowledgement. No, he will not be held liable, or the acknowledgement will have no effect on him unless there is some special relationship between them. In this case, like he pointed out, that if there are two joint contractors, so in that case, if they have agreed that they will be liable for each other's debts and one of them is actually acknowledging, then that acknowledgement will be valid against the other one. दूसरे के अगेंस्ट वैलिड होगा क्योंकि because they stand in a special relationship, special position. Fine, clear? Now it's clear? आगे बढ़े. चलिए, come to subsection 3. Come to subsection 3. Now, subsection 3, come to clause B first. Come to clause B. Clause B पे आते हैं first, then I'll explain clause A. So clause B is saying, basically clause B is trying to say that clause B is saying that Karta's acknowledgement. In a joint Hindu family, Karta's acknowledgement will be acknowledgement on the co-partners. So Karta's acknowledgement is acknowledgement of co-partner. Is acknowledgement of co-partner. ठीक है, अगर एक कर्ता acknowledge करता है, so that will amount to an acknowledgement of co-partners as well. So clause B is trying to say this. So if the karta has acknowledged something, that will be a valid acknowledgement of co-partners themselves. Come to explanation B. आ जाइए explanation B पे. Sorry, subsection clause B पे. Are you guys there?
Yes, sir.
ठीक. Where an agent has been incurred, where a liability has been incurred by or on behalf of Hindu undivided family, by Hindu undivided family, as such an acknowledgement or payment made by the duly authorized agent of the manager of the family, that is Karta, for the time being, shall be deemed to have been made by the whole family. So Karta's acknowledgement is acknowledgement of co-partners or acknowledgement of whole family. So if Karta acknowledges, then you will say that the entire family acknowledges. Acknowledgement by Karta is acknowledgement of entire family, acknowledgement by entire family, acknowledgement by entire family, by entire family. ठीक है, चलिए, this you guys have to write. This you guys have to write. लिखिए. Are you guys writing?
Yes, sir.
If the acknowledgement was made, if the acknowledgement was made by the karta, if the acknowledgement was made by the karta during prescribed period, during the prescribed period, okay, then the acknowledgement will be binding. Then the acknowledgement will be binding. Will be binding upon all co-partners. Upon all co-partners, including any new karta as well. कोई और करता आया था उसके ऊपर भी बाइंडिंग होगा आफ्टर द डेथ ऑफ अर्लियर करता, डेथ ऑफ अर्लियर करता. So this is what explanation B is trying to say. Sir, our partners in a partnership firm, firms are agents in the due course, but there are, when it comes to authorized acts done by the partners, not every act will hold other people liable. For example, if a partner commits a fraud, or if a partner commits murder of someone, it won't hold other persons liable. Now, if you have authorized some duties, now this is where the Partnership Act kicks in. Partnership Act says that some duties have to be expressed and some duties have to be implied. So in a partnership, we imply most duties, like dealing in business implied, working in the ordinary course of business implied, and there are some which have to be expressed. Some duties have to be expressed in the contract, then only you can say that this partner can act in such a manner. So one of the duty which has to be expressed is acknowledgement or admission of liability. That has to be expressed, meaning that the contract of partnership or partnership agreement has to expressly state that which all partners are in a position to admit the liability. Not all partners can be in a position to admit liability. For that matter, not all partners can do all the duties. All of them can do implied duties, but express duties only which the partnership agreements allow. Okay, clear? यहाँ तक clear हो?
Yes, sir.
आगे बढ़े? Should we proceed? अब आ जाओ clause A पे. Now come to clause A. ठीक है. अब देखो, clause A में पढ़ने से पहले I'll have to tell you a story. देखो, prior to, need not write it, just listen it. It's a fascinating story. Need not write it, need not think much about it. Just listen it carefully. Prior to Hindu Succession Act 1955, this is Hindu Succession Act 1955, women did not have right of inheritance or right of succession. They could not succeed a property of the husband. They never got the property of the husband. So if a husband dies, suppose H dies, woman was not entitled to his property. This was the situation which was prior to Hindu Succession Act. Okay. Now, what was prevalent prior? Prior, what used to happen? Prior, there was an act, Women's Right to Property Act. Hindu Women Right to Property Act. Right to Property Act 1937. Now, it gave women some proprietary right. It told them, कि boss, if the husband dies, then you have a right to property over his land. Whatever his property is, you have a right to property over his land, but there is a condition to this. This right to property you have for life. So after your death, this will revert back to the heirs of husband. This will revert back to the heirs of husband. ठीक है, heirs of husband. So कहने का मतलब है कि जैसे if woman has only a life interest in the property, so in this case woman will only have a life interest in the property. This life interest ultimately comes to an end on her death, and then the property will revert back to heirs. So in this case, let us understand the parties. H dies, property goes on to W for life. It is also known as life estate. The moment W dies, the property goes on to heirs of H. Fine. Here the heirs of H are known as reversioner. इनको हम बोलते हैं, we'll call them reversioners. The reason we'll call them reversioners, because the property is reverting back to them. The reason we are calling them reversioners, why such name has been chosen, because the property is ultimately reverting or coming back to them when the widow is dying, when the woman is dying. Okay. So this was the mechanism that was there in Hindu Women's Property Act 1937. Fine. So the mechanism was that widow will have a life estate. After her death, the life estate will the property will revert back to the heirs. Heirs are known as reversioners. ठीक है. अब यहाँ पर explanation A का क्या role है? What is the role of explanation A in all these stories? Explanation A merely says that an acknowledgement of a person who is in life estate, an acknowledgement by a person who is in life estate will be an acknowledgement against the reversioner as well. So if a person who is in life estate, he acknowledges something, that will be an acknowledgement against reversioner as well. Reversioner cannot say, oh, W had acknowledged this, I am not responsible for this. No, since the acknowledgement relates to that property on which W was the life estate, therefore this acknowledgement will be a valid acknowledgement against the reversional as well. This is exactly what explanation A is trying to say. Come to explanation A. Are you guys in explanation A?
Yes, sir.
So explanation A कहने की कोशिश कर रहा है कि an acknowledgement signed or a payment made in respect of any liability by or by duly authorized agent of any limited owner. So the person who is in life estate, limited owner of property who is governed by Hindu law, Hindu Women Properties Act, shall be a valid acknowledgement or a payment as the case may be against the reversioner succeeding to such liability. So jitna bhi acknowledgement life estate mein widow ne kiya, that acknowledgement will be a valid against reversional as well. This is what explanation A is trying to say. Is this clear? ये clear है?
No, sir.
Yes, sir. क्या हुआ? क्या clear नहीं है इसमें? नहीं clear.
सर एक बार और ऐसे ही समझा दीजिए ना.
ठीक है. देखो, एक सेकंड मुझे दो. Let me find a different way to explain. चलो ये छोड़ दो. Hindu Women's Property Act छोड़ दो. Let's say in this case, suppose there is A. Fine. He gives his property to B. Fine. He gives his property to B and he tells them that you will have the property, but you will have this property for life. Only for life. ए अपनी प्रॉपर्टी बी को दे रहा है और बोल रहा है बी को कि तेरे पास प्रॉपर्टी होगी बट ये लाइफ के लिए होगी, इट विल बी ओनली फॉर लाइफ, नॉट मोर देन दैट. सो द मोमेंट बी डाइज, दिस प्रॉपर्टी विल रिवर्ट बैक टू ए. यहां पर एयर्स नहीं है क्योंकि ए जिंदा है ना. The moment B dies, the property will revert back to A. So here A is the reversioner. Why A is the reversioner? Because ultimately, after the interest of B is ending, the property is reverting back to A. A reversioner इसलिए है क्योंकि जैसे ही B का इंटरेस्ट खत्म हो रहा है, प्रॉपर्टी वापस A के पास आ रही है, तो उसको रिवर्जनर ही बोलेंगे ना. अब what explanation A is trying to say? Explanation A कह रहा है कि when B is in life interest, when B is in life estate, and he makes any acknowledgement, when B is residing in life estate and he makes any acknowledgement or admission of liability with respect to this property, property से related कोई भी admission of liability कर रहा है, that admission of liability or that acknowledgement will be a valid acknowledgement or will be a valid acknowledgement against A. So वो acknowledgement valid होगा A के against B और reversioner के against B. जो acknowledgement limited owner ने किया है वो acknowledgement reversioner के against B valid होगा. Simple as that. अब clear?
सर फिर बी डाई है तो फिर ए भी तो मर जाएगा, फिर किसके पास जाएगी?
अगर A भी मर गया तो
हाँ.
suppose तो फिर heirs के पास, तो फिर heirs के पास, heirs के पास जाएगी ना, फिर heirs रिवर्स. ठीक है.
तो यहाँ ए और बी का रिलेशन वही वाला होगा, हस्बैंड वाइफ वाला, या और भी कुछ हो
ये
सकता है?
कॉन्ट्रैक्ट हो सकता है.
डिपेंडेंट.
हाँ कॉन्ट्रैक्ट हो सकता है. मान लो
तो
कि A और B,
हायर्स का इसमें डिफरेंस क्या हो सकता है? हायर्स का जैसे ए का है तो बी का भी तो पॉसिबल हो सकता है.
बी का नहीं, क्योंकि इन्होंने कॉन्ट्रैक्ट किया है ना कि बी के पास प्रॉपर्टी होगी जिंदगी भर के लिए. उन्होंने ये थोड़ी बोला है कि बी के पास उसके बाद प्रॉपर्टी
उनके
होगी,
heirs
बी
के
की
लिए.
जिंदगी
ओके.
भर के लिए होगी. तब प्रॉपर्टी अब वापस ए को जाएगी. अब ए क्योंकि है नहीं तो किसको जाएगी? ए के एलआर्स को जाएगी. आपने मान लो किसी को गाड़ी किराए पर दे दी 10 साल के लिए और आप नहीं हो तो उसको वापस तो देनी है ना किसी को, तो किसको देगा? आप नहीं हो तो क्या बोलेगा कि नहीं देनी मुझे? He will give it to your LRs.
Yes sir.
Same thing is applying here. ठीक है. Clear?
Yes.
So this is what is happening. So basically, suppose such a thing happens that here somewhere this is the prescribed period. Here somewhere the reversioner acknowledges. Sorry, here somewhere the owner, the limited owner acknowledge. The person in limited ownership, he acknowledges. The person in limited ownership acknowledges. Here somewhere the limited owner dies. Now after the death of limited owner, the property will go to whom? बताइए मुझे. Tell me. Tell me jaldi. Reversioner. Now reversioner says that whatever acknowledgement he did here, it won't be applicable against me. So now your suit which you are trying to file is barred by limitation. Whatever suit you are trying to file is barred by limitation. Whatever acknowledgement limited owner made, it is what limited owner made. It won't be applicable against me. Whether this contention is a valid contention?
No sir.
Q, why do you think so? It is not a valid contention.
Yes.
Valid
Sir,
contention.
because limited owner has acknowledged.
Yep. It will be applicable. So here this suit will not be barred by limitation because limited owner has acknowledged, and that will be a valid acknowledgement, and that period will extend. And even if reversioner takes over later on, still he will be bound by that acknowledgement. So this is one thing. So an acknowledgement of limited owner will be binding upon the reversioner. Reversioner cannot, बस इतना ही, reversioner cannot मतलब इतना ही. ठीक है. Clear? Now come to section 18. यहाँ तक clear हो? Section
Yes, sir.
20. Now come to section 18. 18 में I have covered. देखो, we have done section 18. We had done section 19. All the parts. Section 19 में there were two explanations. We did both the explanations. One explanation was usufructuary mortgage. The other was the definition of debt. Debt does not include whatever things are there. Debt does not include a debt payable by decree or order. वही लिखा था. फिर हम section 20 पे गए. 20 में we saw three subsections 1, 2 and 3. First subsection में LCM. Second subsection में savings clause. Third subsection में we saw two things. One is karta, second is limited owner.
Limited owner.
Limited owner and reverse. बस इतना ही तो है. अब आ गया 18 के दो explanation बाकी. Then we'll be done with acknowledgement. Come to section 18. Are you guys on section 18? Section 18 B पर C पर आ जाओ. Sorry, C. Come to C clause. Explanation C. Come to explanation. Section 18 explanation C. Come to explanation C. Pardon? Are you guys on explanation C?
Yes, sir.
An application for execution of decree or order shall not be deemed to be an application in respect of right or property. If I have to very simplify this, if I have to put this in the simplest forms, if I have to put this in the simplest terms, I will say that section 18 is not applicable to execution applications. To execution application. ठीक है? The reason now why it is not applicable to execution application, sir. So I told you what is an execution application. Already a right and liability has been decided. You are just executing it. So there is no point of admitting. The role of admission is not negligent. So just because a person is admitting something, you are not supposed to extend the limitation period. It won't serve any purpose. So therefore, section 18 is not applicable to execution applications. Section 5 is also not applicable to execution.
So please repeat.
Rational.
No, repeat, sir. So please repeat.
जो अभी बोला ना rational ना.
हाँ sir. हाँ.
Section 18 is not applicable to execution application and उसका कारण है. उसका कारण ये है कि already a decree has been decided. Decree or order has been passed, which has already determined a person's right and liability. Already determined हो गया. Now what is required to be done is that this decree has to be executed. मतलब इसको अभी operate में लाना है, operation में लाना है. So now there is no point of admission here. What will you do in admitting? Already the right and liability has been decided. There is no point of admission here. So therefore, we are not supposed to give benefit on the grounds of admission. We are not supposed to extend the period just because a party has admitted liability, because the liability is already decided. Now we no longer need that person's admission. Liability already determined हो गई है. अभी उन्हें उसकी जरूरत नहीं है, उसके मानने की जरूरत नहीं है liability. वो हो गया stage. Fine. अब clear है?
Yes, sir. Thank you, sir.
तो इसके लिए acknowledgement will not be applicable in the cases of execution. Execution में acknowledgement apply नहीं करेंगे. So this is your explanation C. फिर आया एक explanation B मैंने छोड़ा था. I had left explanation B as well. Come to explanation B. ठीक. So explanation B says that the word signed means either personally or by the agent duly authorized. So signed का मतलब है it either has to be signed personally or agent duly authorized. Who is agent duly authorized? बताओ मुझे. Tell me.
So LMC,
LCM.
sorry,
LCM,
LCM.
LCM, correct, LCM, section 20. तो कहने का मतलब है कि what they are basically trying to say that if you are acknowledging under section 18, so not only you personally have to sign, you personally can sign, or your agent can also sign. That is what they are trying to say, simply. Now let us have a quick recap of all the things that we have studied so far. Section 8, acknowledgement. We are done with acknowledgement. Let's have a quick recap. So see, we started with section 18. Fine. In section 18, we only saw one thing, that there is a written acknowledgement. This written acknowledgement is dated, it is signed. Fine, it is a written acknowledgement, it is signed, and it is made to which, to whom? Made to whom? Batao.
Any
Jaldi.
person.
Any
person.
Any
person.
person.
Haan. And it has to be made by person liable.
Liable.
Not only person liable, plus agent duly authorized. Agent duly authorized. Now these were the basic aspects that we went on to understand. Dated में हमने बहुत सारी चीजें देखी कि you can prove oral evidence when it comes to the date. Subsection 2 provides section 91 का बार नहीं लगेगा इसमें. You can prove the date by oral evidence itself. ठीक है. You can infer acknowledgement. We understood explanation A here. Lot of aspects of explanation A were understood here. Fine. Then we went on to section 19. Section 19 the thing was that if you are making a payment, if you are making a part payment, that will amount to acknowledgement, but there is a proviso. What does the proviso say? That it has to be in, batao, it has to be in writing and it has to be signed. It has to be in writing and it has to be signed. Then we went on to understand section 20. Section 20 में हमने देखा, section 20 में हमने 3 subsections देखे. We saw 3 subsections. One was subsection 1, wherein we saw that this is LCM. We saw that the persons duly authorized are LCM, lawful guardian, committee, and manager. Then we went on to understand subsection 2, which provided for exception, which said that, see, just because a person is partner, you cannot hold the other partner liable. Just because a person is contractor, you cannot hold the other person liable. Just because a person is executor, you cannot hold the other person liable unless they are in a special relationship. Fine. Then we went on to understand subsection 3. Subsection 3 we went on to understand 2 things. One was karta. Whether karta's admission will amount to admission of the family. Bataiye.
Yes, sir.
Yes,
sir.
admission of family. And then we went on to understand second aspect. That was limited owners.
Limited owners plus reversal.
Reversed. That is it. ये था आपका पूरा का पूरा acknowledgement. This is your entire acknowledgement. ठीक है. This is your entire acknowledgement. Now come to section 21. Now come to section 21 कर लिया ना, sorry. Section 22.
Yes, sir, we have done.
Come to section 22. Come to section 22. Come to section 22. Are you getting section 22?
Yes, sir.
Yes, sir.
Okay. Now see, section 22 talks about continuing breach of contract or tort. Continuing breach of contract or tort. Breach of contract or tort. Now see, there are certain torts which can be repeated. Which can be repeated. Say nuisance, negligence, and trespass. In such cases, what will happen? The period of which are continuing in nature. There are certain breaches of contract and torts which are continuing in nature and which can be repeated. In such cases, what will happen? The period of limitation will start to run whenever these acts, torts are committed again. जब ये वापस होते जाते हैं, period of limitation वापस start होते रहेगा. For example, what I am doing, I have a house here. See, एक second. गलत घर बना दिया. Suppose I have a property here. and what I am doing, I am putting foul water, or I am releasing foul water in this land, in land of B. So I am ultimately committing nuisance. ठीक है, nuisance ही create कर रहा हूँ ना, foul water B के उसमें डाल रहा हूँ, I am actually creating nuisance. So in such cases, the period of limitation will start when I am releasing foul water. But what if I am releasing foul water every day? Now this is a continuing tort that I am committing. So in that case, whenever I am releasing foul water, the period of limitation will again start from that date. Period of limitation in such cases will run day by day. जब मैं foul water release कर रहा हूँ, तब period of limitation बढ़ेगा, तब मेरी liability create होगी, तब the moment I am releasing foul water, the period of limitation will begin. So this is known as repeated nuisance. In the cases of repeated nuisance, the last time when the wrong was committed, on that time the period of limitation will start. So in the cases of repeated nuisance, or repeated negligence, or repeated breach of contract, the last time when the breach was committed, the last time when the wrong was committed, the period of limitation will start from that period. Okay. Suppose a case of rent. Suppose A is the landlord and B is the tenant. Okay. Now, what does tenant do? She does not pay the rent of March. She does not pay the rent of April. She does not pay the rent of May. So in this case, the period of limitation will not run from March. The period of limit, this is a repeated breach of contract. There is a contract between landlord and tenant that landlord will give the property, tenant will have to pay the rent. यही तो contract है. अब she is committing a repeated breach. So in this case, A can sue her, but from when the period of limitation will start? The period of limitation will not start from March. Rather, this is a repeated breach. So from the last time when the breach was committed, तो उसने अभी हाल ही में मे का रेंट नहीं भरा, तो पीरियड ऑफ लिमिटेशन मे से स्टार्ट होगा रिकवरी का. नाउ दिस इज व्हाट सेक्शन 22 इज टॉकिंग अबाउट. यही चीज सेक्शन 22 बात कर रहा है. एक बार रीड करो. कम टू सेक्शन 22. Are you guys on section 22?
Yes, sir.
So section 22 says, in case of continuing breach of contract, or in case of continuing tort, a period of limitation begins to run every moment of the time during which the breach or tort, as the case may be, continues. तो जब तक tort और breach continue होता रहेगा, period of limitation will begin to run. So जब तक मैं foul water वहां पर B के लैंड में रिलीज करता रहूंगा, तब तक लिमिटेशन वापस कंटिन्यू होते रहेगा. ठीक है. So it will continue the moment whenever I commit a new wrong. Whenever I commit new wrong, the period of limitation will continue. So this is something known as, this concept is basically based upon this maxim. Section 22 is based upon this maxim, जिसको हम बोलते हैं D die dime. D die dime, which means day to day. Which means day to day. Din bar din. It is based upon this concept, day to day. So in this case, what is happening? The date is reckoning. The date of period of limitation is reckoning every time the wrong is committed, because it's continuing nature. And if it continues, the period of limitation will again reckon again and again, as long as it is continuing. This is what section 22 is talking about. लिखिए. लिखेंगे?
Yes, sir.
So in cases of tort, or breach of contract, if the wrong continues over a period, of time, then the date of reckoning the date of reckoning will start every movement, every next movement will start every next movement. एक second, just give me a second. The period of limitation will start. Then the date of reckoning will start every next movement. The wrong is committed. Every next movement, the wrong is committed. Fine. Therefore, the counting of prescribed period will be done from the date when last time wrong was done. Okay. What are the examples of continuing wrongs? Now, this does not apply in all cases, right? It only applies when the wrongs are continuing or when there is a continuous breach of contract. What are the examples of continuing breach or continuing wrong? See, the examples are for tort. For tort, you can say these are the examples. For tort, you can say nuisance is one example. Nuisance is a continuing wrong. जो मैंने आपको बताया, foul water. Negligence is also a continuous wrong. Trespass is also a continuous wrong. Okay. In the cases of contract, one is payment of debt. If the debt is in installments, then it can amount to a continuing wrong, and then continuing breach of contract. And then comes tenancy agreements. If something is required in tenancy agreements to be done, and that is not being done for a long period of time, then till the time it is not done, or as long as the breach continues, the period of limitation will start to run from that date. So these are a few examples of tort and contract. This is it for today. We'll बाकी का करते हैं Monday. All the best for your MP Judicial Services prelims. Guys, do well in the examination.
Thank you, sir.
Okay.
Sir, what's after negligence?
Negligence, trespass. Yes, Sanskriti.
Sir, am I audible?
You're audible.
Sir, so if a person continues to trespass at my property, that will be considered
Continuing
and
wrong.
and the day he leaves, that day the period will be refreshed.
Yeah, the day you leave, that period will be refreshed. Correct.
Okay, sir. Thank you.
Yes, Anukriti.
Sir, am I audible?
Yeah, you're audible.
सर थोड़ा ऑफ द टॉपिक है, पूछ लूं क्वेश्चन?
पूछ लो.
सर मुझे ये चीज पूछनी थी कि सर जैसे एक्सक्लूजन और एक्सेप्शन के केस में सर हर एक जगह कॉम्प्यूटेशन दिया है पीरियड ऑफ लिमिटेशन का, तो सर क्या इस कंप्यूटेड पीरियड ऑफ लिमिटेशन को इफेक्ट देने के लिए कोई और प्रोविजन भी है कि इसी में इम्प्लाइड होता है कि
इसी में
अब
यही तो कंप्यूट कर रहे हैं, इसी को तो कंप्यूट कर रहे हैं.
ओके सर, वो ओवरथिंकिंग की वजह से मुझे लगा कि कोई इनहेरेंट पावर सीपीसी के अंदर यूज करते हैं.
नहीं, इसी में कंप्यूट.
ओके,
ठीक है. यस नूरी. यस नूरी.
सर ये जो आपने बताया ना सर लास्ट डेट, फॉर एग्जांपल कोई मतलब मेरे घर पे फाउल वाटर फेंक रहा है तो कंटिन्यूअसली फेंक ही रहा है, तो मैं जब पहली बार फेंका उस दिन सूट नहीं कर सकती ना?
सूट आप कभी भी कर सकते हो, ये पीरियड ऑफ लिमिटेशन की बात है ना. लिमिटेशन का
फिर ये जो है लास्ट डे
ये
वाला
पीरियड ऑफ लिमिटेशन, देखो अब ये इसने आपको इसने फाउल वाटर पे फेंका आपके उसमें, ठीक है. उसने फेंका मार्च में और उसने अप्रैल तक फाउल वाटर फेंकता रहा. मार्च में शुरू किया, अप्रैल तक फॉल वाटर फेंकता ही रहा।
जी सर।
आप तो सूट मार्च में ही फाइल कर सकते थे,
हाँ सर।
बट ये पीरियड ऑफ लिमिटेशन रिन्यू होते जाता है, रिन्यू होते जाता है, रिन्यू होते जाता है। तो अब जब अभी अप्रैल के बाद फाइल करोगे ना, तो हम मानेंगे कि लास्ट डे अप्रैल से मानेंगे कि जब उसने बंद किया था, और उधर से पीरियड ऑफ लिमिटेशन स्टार्ट।
मतलब अब अप्रैल में फेंकना बंद किया था, फिर हम कोर्ट को बताएंगे कि मार्च में ही स्टार्ट कर दिया था ये।
हाँ, वो हम पीरियड ऑफ लिमिटेशन की बात कर रहे हैं। आप तो मार्च में ही सूट फाइल कर सकते हो। जब पीरियड ऑफ लिमिटेशन की बात कर रहे हैं तो हम बोल रहे हैं कि डेट हम कब मानेंगे, डेट ऑफ रेकनिंग हम ये मानेंगे कि जब उसने लास्ट खत्म कर दिया था। तो इसने अप्रैल में खत्म किया था, तो हम मानेंगे डेट ऑफ रेकनिंग अप्रैल है।
पर कॉज ऑफ एक्शन तो सर मार्च में शुरू हो गया था।
हाँ, बट क्योंकि रिपीटेड है ना, तो
हाँ,
बेनिफिट देने के लिए आप उसको बेनिफिट देने के लिए अगर आप सिर्फ मार्च का कंडक्ट करोगे तो फिर तो ये बेचारा करते जाएगा और सामने वाले का पीरियड एग्जॉस्ट हो जाएगा, तो प्रॉब्लम हो जाएगी ना। तो आप सामने जो बंदा सूट कर रहा है आप उसको बेनिफिट दे रहे हो ना। आप उसको
हाँ,
ये बोल रहे हो कि यार जब ये लास्ट टॉट करेगा, जब ये
हाँ,
क्योंकि रिपीटेड
हाँ,
टॉट है, जब ये लास्ट करेगा तब से हम पीरियड ऑफ लिमिटेशन डेट ऑफ रेकनिंग स्टार्ट करेंगे, which is a good thing, which you are giving him a benefit ना।
जी सर। सर आपने ये कॉन्ट्रैक्ट में जो बताया था डेट इन, मतलब वो वाला बता
वो
दीजिए।
डेट इन इंस्टॉलमेंट्स है, दैट इज अ डिफरेंट इशू। वो अगर कॉन्ट्रैक्ट में स्पेसिफिकली स्पेसिफाइड है, दैट इज अ
अच्छा
डिफरेंट।
सर, ये जो 2(3)(b) है ना, वो क्या है सर? स्लाइड नंबर 13 में था शायद, 13।
13 में
हाँ सर, हाँ ये वाला, नहीं 13 सर।
ये
हाँ, इसमें 2(b) 2।
टू
हाँ,
सेविंग्स क्लॉज है ना।
हाँ, सेविंग क्लॉज, फिर वो कर्ता वाला हो गया,
ये
और फिर
लिमिटेड ओनर प्लस रिवर्सर।
लिमिटेड ओनर प्लस रिवर्सल। उसके रिलेटेड एक क्वेश्चन था सर। मतलब मतलब अगर W एक्नॉलेजमेंट कर गई है ना सर, फिर उसके इमीडिएट बाद ही, फॉर एग्जांपल उसने मतलब
डेथ हो
1
गई।
तारीख को, हाँ, एक्नॉलेजमेंट किया, फिर उसके इमीडिएट बाद उसका डेथ हो गया, तो डायरेक्ट रिवर्जनर्स के पास जाएगा, जो भी एक्नॉलेजमेंट उन्होंने किया सब पैसा उनको देना पड़ेगा, है ना सर?
हाँ, करेक्ट।
अच्छा, ठीक है सर, थैंक यू।
यस दीपांक।
गुड इवनिंग सर।
गुड इवनिंग।
मुझे तो सर वैसे आंसर मिल गया। एक सर क्वेश्चन टीपीए से रिलेटेड है।
अभी मत, टीपीए नहीं।
सर प्लीज सर, छोटा सा है।
पूछो।
सर अगर जॉइंटली ओनर हैं और एक स्पाउस की डेथ हो गई है, तो उसमें सर जो एग्जिस्टिंग स्पाउस है वो अपना उसको क्लेम कर सकता है डेथ सर्टिफिकेट के थ्रू, और जो उनके लीगल एयर्स हैं क्या उसमें कोई डिस्प्यूट क्रिएट कर सकते हैं?
लीगल एयर्स नहीं, जॉइंट ओनर्स हैं तो नहीं क्रिएट कर सकते। सक्सेशन आपको मिल जाएगा।
नहीं, लाइक
को-ओनर्स में
हस्बैंड की डेथ हो गई, हस्बैंड वाइफ दोनों के नाम प्रॉपर्टी थी,
हाँ, वाइफ को हो जाएगा, जॉइंट है ना। को होते तो दिक्कत होती।
तो वो सीधे ट्रांसफर म्यूटेट हो सकता है उनके नाम?
हाँ, सीधे ट्रांसफर म्यूटेट हो सकता है, सक्सेशन की भी जरूरत नहीं है।
सक्सेशन की भी जरूरत
नहीं, सक्सेशन सर्टिफिकेट की जरूरत नहीं है।
ऑन द बेसिस ऑफ डेथ सर्टिफिकेट?
हाँ, ऑन द बेसिस ऑफ डेथ सर्टिफिकेट।
ओके ओके, थैंक यू
जॉइंट
सर।
यस अदिति कुछ
सर थोड़ा सा सिली है बट स्टिल सर आपने एक्नॉलेजमेंट में बताया था ना कि राइटिंग और साइन होना जरूरी है। तो इन जनरल लाइफ में ऐसा थोड़ी होता है, जैसे ट्रस्ट में आपने मुझे 10 लाख रुपीज दिए, अब मैं आपको इंटरेस्ट उसका पर्सन टू पर्सन आके दे रही हूँ, तो उसका एक्नॉलेजमेंट कैसे प्रूव करूंगी? मतलब राइटिंग साइन कुछ भी नहीं है
कुछ, इसलिए तो हम लिखाते रहते हैं, इसलिए तो मेल करा के लिखते हैं, कुछ स्टेटमेंट लिखा के रहते हैं कि लिख लो, आप साइन कर दो कि इतना अमाउंट पे किया, तभी तो हम लेते हैं। रिसीट का कॉन्सेप्ट यही तो है, पीछे हम साइन करके लेते हैं, डेट लेते हैं।
तो सर ऐसे बाकी प्रूव नहीं हो सकता ना?
ऐसे प्रूव नहीं हो सकता, तभी तो कंपनीज जब आप पेमेंट करते हो तो आपसे पहले ही बोलते हैं ना कि
सर वो तो एक कॉन्ट्रैक्ट एग्रीमेंट टाइप हुआ, ऐसे ट्रस्ट में जैसे कि कोई रिलेटिव हो गया या फैमिली फ्रेंड,
ऐसे नहीं हो सकता। प्रूफ कैसे करोगे? प्रॉब्लम ये है ना, तो हम कॉम्प्लिकेशन लिमिटेशन में नहीं क्रिएट करना चाहते, बिकॉज ये है प्रिलिमिनरी क्वेश्चन, ये पहले ट्रायल के पहले डिसाइड होता है ना। तो हम इसमें भी इतने सारे एविडेंसेस लेने शुरू कर देंगे, इतने सारे विटनेसेस खड़े करने शुरू कर देंगे, तो प्रॉब्लमेटिक सिचुएशन हो जाती है। तो हम चाहते हैं कि लिमिटेशन का क्वेश्चन ऐसे डिसाइड हो कि एक डॉक्यूमेंट हम प्रेजेंट करें और उसको देख के ही पता चल जाए कि लिमिटेशन कि अंदर है या नहीं है, तो इसलिए ये सीन है.
Okay, sir. Thank you, sir.
Yes, Lokesh.
Sir, acknowledgement of hairs.
Acknowledgement of
Hairs.
hairs. Acknowledgement of hairs. Acknowledgement by hairs or acknowledgement of hairs. What is the question?
Acknowledgement by hairs.
Acknowledgement by hairs will not amount to acknowledgement of co-heirs. They are in different capacities. Will not
Okay.
amount to. They are in different capacities.
In case of acknowledgement of hairs, sir.
Acknowledgement by any person. That
No,
depends.
not like that, sir. Like, if I acknowledge death of my dad, would that
you can
amount?
do. No, dad will not be liable.
He will
Suppose
not be liable.
S is acknowledging his dad's debt.
Okay.
So S is personally liable. F is not liable.
No, he is acknowledging the death of father.
As in, so that
Yeah.
that is between you and the debtor. No?
No,
Father
sir.
has no responsibility.
What I'm asking is, so when the hair is not authorized, so does it require?
Father has taken some debt and
debt,
S
and the
is
son
agreeing to,
yes,
admitting.
yes.
That is not a valid acknowledgement.
Okay. What if the father died and the property is on? Then
it can be. Then it can be, because he's a then it will be a lawful guardianship. Then it can be.
Okay.
Then
Thank you.
Yes,
One. I'll just add to this.
Yeah.
The acknowledgement has made when the father is alive and the father died later on. Would
Not
that
a valid,
amount?
Not a valid.
That would not amount.
He's not in a capacity to acknowledge.
Right, sir. Thank you. Thank you so much.
Yes, Sanskrit.
Sir, I was doing some work, so उसमें एक question था, sir ये इसी से related है. So basically, can जैसे एक बुआ होती है, so can she claim it from her brother's property, self-acquired property?
Bua, sister.
Yes, sir. If a sister can.
Class 2 heir.
But sir, the heirs are already existing. There's a stepwife and there's a son.
Son है तो
नहीं कर सकती ना from the self, but अगर like proper property होती, if it was not self acquired,
then it is a different issue. मतलब वो फिर तो आप उसमें जाओगे ना, partition करना पड़ेगा उनको. अगर family property.
But sir, sister cannot acquire, so she has the right in her father's property,
but not in brothers.
Not in brothers' property.
Correct.
Okay, sir. Thank you.
Yes, Chitrangada.
So acknowledgement of debt by a father in respect of a debt that he has taken will be valid acknowledgement against his legal heirs after his death, right?
Acknowledgement of father with respect to the debt he has taken
but while he was alive.
But that is between father and him. If
no, but then the estate will go to the legal heirs.
If the state goes and if the debt is associated with the state, then it will be a valid acknowledgement. Otherwise, it is only in that case. Otherwise, see, a son is not responsible for father's debt, right? We have abolished pious obligation.
So, but in a recovery suit, if somebody wants to go for attachment of property of a deceased who has acknowledged the debt during his existence, then the parties will be the legal heirs. So in that case, he can use that acknowledgement.
See, there are two things. Now, one is, there are two things. Let me erase this. See, there are two things. There are two concepts here. One is that, see, if a property is devolved, a estate is devolved, and the debt is associated with the state, means the person has a charge over the state, then the debt is also inherited by the person who is inheriting the state. That is a different issue. In that case, if that is so, then the acknowledgement of the father will be liable, or the admission made by the father will be liable on son. But if it is only a debt which has no charge over the asset, in that case, no. The basic reason is because earlier this was the case. Earlier it was yes, because pious obligation was applicable. Now we have no pious obligation. So father is not responsible to pay son's debt. Oh, sorry, son is not responsible to pay father's debt at present. Now it's clear.
Yes.
So which the scenario which you are talking about is when a person has a charge on the asset, which is true, which can happen.
Yes. Thank you.
Clear? And
Sir, I
Anji.
have also got it out. Can I ask?
Yeah, ask question.
So, sir, imagine there is a father who is a Hindu, but he has like 2 children with his marriage. Then he later on converts to Islam. Now he can claim the proper ancestral property because of caste disability removal act, but can the children claim their right in the ancestral property?
No.
So, but why? Like
Section 25 or 26, section 26 or 27 of Hindu Succession Act. That is the reason. All descendants are.
Sir, isn't this unreasonable, because the children were born and they were brought up as Hindu only, born and brought up as Hindu.
This is not unreasonable. No. Okay. Children born prior. Children born after will not.
Yes.
Children born prior will get the benefit. Will get the estate. उसमें लिखा है ना after birth. The section mentions it.
Okay. And if they are born after the marriage, then they can't.
They can't. Then they can't.
Okay, sir. Thank you, sir.
Chalo guys. See you on Monday.